Welcome to the e-commerce IP report.
Hello, everyone, and welcome to the e-commerce IP report with Adam Urbanchek. Adam is the principal attorney at AU LLC, a Chicago law firm focused on intellectual property litigation, e-commerce disputes, and helping businesses protect their brands in a rapidly evolving marketplace. I'm Sean O'Connor, and today Adam and I are discussing what Amazon sellers should do after receiving a Schedule A lawsuit. Adam, good to see you.
Good morning, Sean.
Hey, let's, since this is the inaugural episode, let's start by cluing listeners in on how you got into this particular practice area, e-commerce, intellectual property. Give them a little background, and we'll go from there.
Sure. So our practice was founded back in 2012. I'm a registered patent attorney for the USPTO. So we were handling intellectual property matters kind of generally, probably more on the prosecution side.
Mm-hmm.
And then perhaps around 2017, 2018 or so, we started representing, probably by virtue of the fact that our office is located in Chicago, in which the U.S. District Court for the Northern District of Illinois is located. That is a bit of a ground zero for Schedule A litigation throughout the country. Other courts, it occurs in other courts too, but that's most of the cases which have been filed in this vein had been filed there. So we just have happened to be in the location where it was happening, and then by virtue of regular SEO and then referral business, we picked up more and more clients, and we've been doing it in earnest since then. Our practice has been representing many, of course, predominantly foreign Chinese resellers who are involved in these types of cases. And then we represented some plaintiffs. So on the other side of the aisle too, with the same types of claims and facing the same type of procedural questions and jurisdictional questions.
Got it. No, that's helpful. So let's start out with just what's a Schedule A lawsuit? And why are Amazon sellers so frequently targeted by them?
Well, Amazon sellers are targeted by them, I guess, by virtue of the fact that Amazon is going to be the largest marketplace. And at least, if we're talking about the United States, those payment accounts on the Amazon US platform are going to be reachable by temporary restraining order or a court judgment that issues from a US district court. Mm-hmm. There are other marketplaces that also operate here in the United States.
Sure.
There's Shopify, there's eBay, there's Walmart. Temu is a newer one, and there have been others that have come and gone too. Like I guess Wish might still be around. I think there's Shein is around too. So that has changed. What hasn't changed is Amazon being the 800-pound gorilla in the e-commerce marketplace, of course. So that's the biggest market. That's where most of the activity, authentic or otherwise, is occurring. So most of the time, the defendant profile in these cases are going to be Amazon sellers. But there are still there's no shortage of Walmart sellers or Temu sellers or Shein sellers or businesses that have Shopify accounts are also located and or also find themselves on the receiving end of these types of Schedule A lawsuits.
Mm-hmm. It's what's a Schedule A lawsuit? For me,
It's going to be an intellectual property lawsuit. So there'll be trademark infringement claims, copyright infringement claims, design patent infringement claims, utility patent infringement claims to a lesser extent, against a group of sellers who most of the time are anonymous at the outset of the case for a couple of reasons.
Mm-hmm.
But those are organized in a schedule or an exhibit. So the schedule is really a type of exhibit that is itemized in some fashion. So they call it a Schedule A.
I see.
There was some convention started years ago where they just called it Schedule A, I guess, for some practical purpose. Sure. And hence everybody just says this Schedule A. It could be Exhibit A lawsuits. It could.
Okay. So it's just some, a term of art within the trade, so to speak, that came about. I wasn't sure if I was missing something there. I get it.
Sure. So as far as the type of the litigation is, and it's been covered recently, quite a bit as a result of, at least from the academic lens, some criticism over how the cases proceed.
Hmm.
And there are different views on that. But the the basic of a Schedule A lawsuit is a rights holder, whether you're a copyright holder or trademark right holder or a patent holder or something. They're going after a group of defendants, all at the same time. In one case, alleging that based on the profile of the defendants, that they're going to be related, and thus the court is permitted to join them in one lawsuit.
Okay.
The case is filed. Simultaneously with the filing, the rights holder will file a motion for a temporary restraining order under seal, in addition to sealing certain aspects of the case filing. So like the Schedule A itself, the list of defendants, that's usually going to be sealed. There'll be a motion for a temporary restraining order that is intended to force or order the platforms to take the offending listings down, locate assets that are associated with the accused sales, restrain those, um, allow for some expedited discovery so the plaintiff can figure out who the defendants are initially from the platform itself, because the platform will have those defendants' registration information,
Hmm.
ostensibly the address and a point of contact, things like that. Um, the defendant will, or the plaintiff will also ask for leave to serve the defendants electronically via email and not have to go through the tremendous hassle, or it might be practically impossible for a couple of reasons to
Yeah.
actually knock on doors and hand
Yeah.
people papers
Deliver.
in Shenzhen.
Yeah.
That can be an issue. So there's motion practice on that. There's motion practice on everything else. Those requests are going to be supported by some evidence. So you file a lawsuit, you're generally not going to have to plead your evidence in most contexts. But if you're asking the court for some extraordinary relief under Rule 65, if you're in federal court, you're going to need to bring some evidence and then show the court that you're likely to succeed on these claims. So
Yeah.
you should do X, Y, Z.
Yeah.
That evidence is going to be most of the time screenshots of listings that show the infringing activity.
Mhm.
There can be pictures of test spies that the plaintiff's investigator, or their attorneys order into the jurisdiction. They'll identify what's wrong with them, like these are inauthentic for XYZ reasons, or these
Yeah.
products are
Counterfeits.
infringing the plaintiff's patent for these reasons in a claim chart or something like that.
Mhm.
That's submitted to the court along with with their Rule 65 motion, along with a declaration from somebody on the plaintiff side saying that this is what it is and this is true. The court will review all that, make a determination, and then what the plaintiff is looking for is a temporary restraining order that will command the plaintiffs to shut things down temporarily, at least temporarily.
Yeah.
And then allow for some expedited discovery. And then at that point, the defendants are made aware of what's going on because, hey, I can't access my Amazon account.
Yeah, I was gonna ask you, how do they find, you mentioned, serving via email. I was wondering how these sellers find out that they're, named in one of these suits. Is it just like one day they wake up and their shop isn't working?
Yeah, that's going to be most of it. That's going
Yeah.
to be the first thing they hear about. So, in the platforms respond to those orders more or less promptly. I say for the most part, like Amazon, if they're receiving a TRO, they're going to act in just a couple of days. That's going to be quick. But Amazon, again, is enormous. They have a large team that's dedicated to just processing TROs and subpoenas and all of that.
Yeah.
So we can turn around that activity pretty quickly. Other platforms may not be as responsive. In our experience, Walmart takes a little bit more time. Temu is pretty prompt. Shein is pretty prompt too. But then other platforms that may or may not exist any longer didn't respond as well, probably for some basic logistical reasons. They didn't.
Yeah. They know the infrastructure.
Right. So yeah, they're going to find out about, the defendant's going to find out what's going on because the platform sends them a note saying, hey, we received some notification from XYZ court. Here is the plaintiff's attorney's contact information. Reach out to them. Here's the case number. And then that's it. And that'll happen I mean, that'll happen before even electronic service is made, presuming the court allows the plaintiff to do that.
Right.
So that's going to be in the first couple of days. So usually after the TRO is entered, you would send it on the plaintiff side, you send it to the platform. You might start hearing from defendants asking what's going on, or they're apologizing or whatever. That might happen in just a couple of days.
Yeah. Are there mistakes? Do sellers make mistakes in the first few days after learning that they've been sued that you've seen?
Yes, I think probably typical of defendants in other cases. Maybe they what they might do is understand it's a problem, and in haste to get over the issue and have the matter resolved,
Mm-hmm.
and just get on with their storefront, because if
Yeah.
they have some storefront and they're selling a certain amount of money,
Yeah.
a certain amount every month or every day,
Yeah,
or
it's a
something,
business, right?
their priority is getting that up and running and having access to those funds, because they need that to order inventory and so on. So what they may do is reach out to the plaintiff's counsel and, I guess, acknowledge and or admit that what they did is violating any of the plaintiff's rights.
Mm-hmm.
Maybe misunderstand exactly what they're being accused of. Because once they receive the notification, once the TRO is entered, the platform will notify the seller that they're involved as a defendant in a suit. They'll usually provide, say, the case number, and in most courts, most cases, at least the complaint is going to be unsealed, and then there will be portions of the file, the pleadings, like the Schedule A, maybe the exhibit to the complaint that contains the intellectual property rights at issue. So
Yeah.
the patent itself, that might be under seal. The trademark registration that's being enforced, that might be under seal. The plaintiff does that because they don't want to have that stuff public and then tip off seller communities, so they see that the day it's filed, and then they take actions that might vitiate some of what the plaintiff is trying to do.
Right.
In other cases, in other courts, they will allow the entire case to be sealed. So you're not, even if you have a PACER account, for example, and you're a defendant, you're relatively sophisticated, you're not going to be able to dig up exactly what's going on. So, a mistake might be reaching out too quickly before you have a firm grasp of what you're being accused of,
Right.
and just apologizing, acknowledging, making admissions to the plaintiff's attorney that you did something.
Yeah.
As the seller, you might have an idea of, I guess you should have an idea of what you're selling. At least I'm aware that we have these ASINs. Maybe you didn't know that there was a problem with some aspects of the listing, or you pulled some photos off of 1688.com, and if you didn't take a good look to see that the sweatpants the girl was wearing had a swoosh on it, you just copied and pasted. Like, maybe that's what you did. And I think that's what happens, maybe a healthy majority of the time. So say 60% in our
Right.
experience.
Just sloppy, lazy co-opting images. Then
I mean, you could, I don't know, but maybe it's sloppy. I think, if you're an e-commerce seller, you want to sell lots of products. You're chasing trends necessarily.
Yeah.
Most sellers are not, conglomerates. They're not like huge organizations. So
Right.
I think a lot of it can be not forgiven in the context. It's not, they're still responsible for it, but
Sure.
maybe it's understandable how it happens very often.
Yeah, it's not a vast conspiracy per se. It's
No, I wouldn't say it's a vast conspiracy. No, in a political sense, no. That being said, I mean, there are organizations, to use that term very loosely, that do, intellectual property infringement and counterfeiting and fake goods is a significant problem, and that's undeniable. And the amount of money is just in the United States that's lost to sales of goods that are inauthentic is
huge.
tens and tens of billions of dollars. Every year that CPB is publishing reports over what their seizures are, and that's what percentage of the things they seize
Yeah,
are.
that's what they got. Yeah.
That's what they got. Like the drug trade almost. Like
Right. Wow.
these busts are great, but if that's how much you're getting, how much you're not getting is more alarming. So it's a serious problem. It's just in our experience on the defense side, it's not tremendously willful. It might be reckless. I guess they just didn't know. But then there are other defendants who absolutely know what they're doing, and it is deliberate. And there are some fingerprints on that kind of behavior too. So it goes both ways.
Yeah. No, I get that. What could happen? Let's say a seller's business or marketplace, they're suspended. What happens if they don't respond quickly?
If they wait, so if I'm a defendant on Amazon, I'm a seller on Amazon, and I get a notification from Amazon that one of my listings was shut down, my account's frozen. I decide not to do anything. Either I decide not to do anything, or perhaps I have a number of storefronts and I just missed the email.
Yeah.
Because I have a lot of stuff going on and I just missed it.
Yeah.
And I can't manage all of these storefronts and all of these ASINs every single day.
Yeah.
And I have all of these accounts, and maybe one of them had $500 in it, and that's not really putting a dent in my cash flow. So like, oh yeah, I had no idea, because we're doing XYZ volume, and it didn't, it wasn't that impactful.
Yeah.
If they don't act quickly, I suppose, once they find out about the case, most of the time it's because the TRO was entered. So that's going to be a restraint that the account is imposing, that the platform is imposing on the account. And they can object to, they can move to, vacate it for one or more reasons. The temporary restraining order is temporary. And if the rights holder wants to continue that restraint, they'll have to convert that into a temporary or a preliminary injunction. Effectively at some point. Usually it's going to be 14 or 28 days later. The court, the rights holder might move to extend the TRO for another 14 days if they're waiting on discovery that's like lagging from a particular platform, or need some more time to serve everybody. But if they don't respond again, then I guess the preliminary injunction will be entered, and then that is going to be restraining everything for the duration of the litigation.
Got it.
If they still don't do anything after they're served, at some point the plaintiff will move for entry of a default judgment. It's maybe like a move for entry of default, and different courts handle it a bit differently. But the plaintiff will be asking the court to have the clerk enter default for the defendants who haven't responded to the complaint in the 21-day period. And then at some point, sometimes coincidentally with that request, or sometime after that request, the plaintiff will ask the court to enter default judgment, in which the court's going to be, granting the plaintiff the relief it's seeking, at least from an adjunctive standpoint. The plaintiff can be asking for, maximum statutory damages or whatever. But it doesn't mean that the court is going to just grant that automatically. But once that's entered, then you have this judgment. Then the plaintiff will take the judgment and send that back to the platform and ask the platform, liquidate, at least, permanently shut the ASINs down. If you're on Amazon, for example, shut the ASINs down, and then liquidate the account, whatever's in there, up to the judgment award. And then if there are other, email addresses or other contact information that was disclosed by the platform, the plaintiff can then sort of march around platform to platform. They might ask PayPal, hey, have you seen this email address? Can you identify any accounts associated with this email address? Okay, great. How much is in that account? And they'll just, seek to enforce the judgment there. Now, at what point have you not acted, at what point it's not that you're not acting quickly, it's you're just disregarding the matter entirely.
Right.
There's a line to draw there.
Right.
But surely all defendants will want to avoid a default judgment.
Yeah. Well,
that's definitely a goal.
I get it. Well, Adam, with we've got just a couple of minutes left. I want to just sort of shift it a little bit and ask you, for folks listening out there, Is there anything Amazon sellers can do proactively, to reduce the risk of ending up in one of these lawsuits in the first place? Can you give a couple of best practices real quick?
The thing to avoid, now this is what we find on the defendant side, what gets clients in trouble the most is taking content from supplier websites like 1688.com and then just copying and pasting it.
Oh.
I mean, that's something I know it's 2026. Nobody should be doing that, going online and copying things, whether it's Google Images or it's something on a web. Like, don't be copying and pasting anything. Don't be taking photographs from listings and then repurposing them.
Right.
They may look professional and great. You may just be interested in reselling those products. So there's a supplier. You want to just pull that stuff from overseas and then sell it through your Amazon storefront. Don't take the listing photographs if at all possible. They might be subject, or they're going to be, if you didn't take the photographs, they're going to be subject to somebody else's copyright interest.
Yeah.
If it's copy, if it's a website copy or like listing copy, the copyright protection in that might be vanishing. It might exist. It might be vanishingly thin, but you're going to want to make sure you read it. And there could be trademarks buried in there you may not appreciate. Not everything is Nike or Lululemon or Louis Vuitton. There are millions of copyright or trademark registrations, many of which are for things that aren't that remarkable and you could miss and you might not appreciate. Well, best practice is just to have everything original to you and to write your own stuff. That's the number one thing to do. And then second, if you are on if you do find yourself on the receiving end, definitely do some research before you would ever reach out to the plaintiff's counsel, if that's even advisable.
Right.
There are, we have ChatGPT. We have, if you have an e-commerce platform, you have access to the internet. There's a lot of information available about these types of cases. They've been going on for 10 or 15 years, at least. We've been doing it for coming on 10 years or so. We've been involved. And it was going on probably going back to like 2006, maybe in the aughts. Not to the same volume, but there's a lot of information. Don't race to do something because you're interested in getting the store back up and running.
Understood.
Almost anything. Educate yourself a little bit, and then reach out to counsel and ask for some options.
Got it. Well, thanks, Adam. Sorry to cut you off. We're out of time, but good stuff for sure. Great talking to you. Thanks for sharing your expertise, and I look forward to future conversations.
Sure. Thanks for your time.
That's it for this episode of the E-commerce IP Report with Adam Urbanchek. To learn more about Adam's practice, visit au-llc.com. Thanks for listening, and do us a favor. Leave us a review, subscribe to the podcast, maybe share a link with someone in your world who would find this content helpful. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.